नमस्कार, आदाब, सत श्री अकाल दोस्तों। स्वागत है आपका एक बार फिर से हमारे YouTube चैनल ब्रास फ्यूजन्स पर, जहां हम आपके लिए एक बार फिर से लेकर आए हैं एक नया लेसन।
Looking at the way in which executive power is exercised in India, and we were looking at Article 74, and I hope that you can tell me at the end of the class, okay, Surya? I won't be able to note down like this. Have you all read the case and come? Okay, good. Okay, now look at Article 74. So today what we're looking at is the aid and advice, and I'm going to do it for central government, for state government, 163, 74, and then 239 AA. So we're going to be doing two judgments, the Shamsher Singh judgment as well as the government of NCT. The government of NCT I will be taking up tomorrow. I expect everybody to have read it and come. Okay, you're not going to follow or you're not going to get as much out of the class unless you read these cases and come. I'll tell you very clearly. Because you're not here, as I see it, for attendance. You're here, you want to learn more. If you want to learn more, you have to read the background material and come. Believe me that your insight and your understanding and then your critical abilities to see what the judgment is saying will expand and improve greatly if you came prepared into class. I have to say this because there are too many of you for me to individually ask a question. But I must tell you this, don't shortchange yourself, okay? Don't have such a miserable goal कि मेरे को exam pass करना है. ऐसे goal मत रखिएगा. Okay, that's very low level goal. You've come to study, you want to study constitutional law, set your goal higher. And your higher goal has to be, I want to understand critically all the debates that people are seeing. Those simple, small, subtle points that people are making in articles, I must be able to understand. If somebody asks me what is going on, I must be in a position to answer. And to get all that, you must read alongside, If you just are going to spend 2 days with the Dukki, fine. Pass for exam passing, I don't like the Dukkis, I have to tell you. I really think that you must study the case material. But your goal in law faculty is not just to pass the exam. Otherwise, you wouldn't be attending class every day, right? 5 hours a week we're studying constitutional law. So then we must take out of it. Now, the question to ask is, I'm going to ask a very fundamental question. If you look at Article 74, it says there shall be a council of ministers to aid and advise the president in all his functions. The first point I want to make is it doesn't say merely executive functions, it says all his functions. And therefore, the takeaway from the Shamsher Singh's cases, these functions could be pure executive functions which the president has under 53. But 74 uses a little more cryptic phrase. So look at it. Just please open 74 so that we know. Let me begin. I'm going back a little bit and repeating what I did in the last class, but doesn't matter. There shall be a council of ministers with the Prime Minister at the head to aid and advise the President, who shall, in the exercise of his function, act in accordance with such advice, in exercise of his functions. So we know that because we don't have strict separation of powers, these executive functions could be partly executive, they could be partly legislative also. What are those partly legislative functions? For example, President issues an ordinance under Article 123. So when the President is issuing this ordinance, he is actually exercising legislative power. When Article 74 says, in the exercise of his functions, is it speaking only to the pure executive functions which are covered under Article 53, or would it also cover these legislative parts of the presidential functions or not? And my point is that because we are students of law, we must straight away, our brain must think like this. Article 53, look at Article 53. This is how a lawyer thinks, and this is how you will develop good arguments in court. 53 says the president, executive power of the union shall be exercised by the president, which clearly means part of his functions are executive functions. But here there is no mention of executive. It merely says his functions, which means that it is obviously broader than just the executive functions that that we are dealing with. So is there a distinction between his function and executive function? So the moment you see the lack of symmetry in these phrases, it raises a question. Now Shamsher Singh tells us that the aid and advice is for all the functions of the president. There had been a doubt on this point earlier, and I'm going to come to the way in which the 7-judge bench decision in Shamsher Singh, with 2 judgments, Justice A.N. Ray for himself and 4 other judges, and Justice Krishna Iyer for himself and Justice Bhagwati writing the concurring judgment. Okay. So there's no dissenting opinion there at all. And the question that is asked is there a difference between executive function and his function? And I'm going to ask you a question very shortly about whether Amrit Lal Shodhan's case, what exactly was Shamsher Singh's view on that? What was its view on the Sardari Lal's case? If you have read the judgment but you can't give me an answer to it, then you've not read it well enough. You've not read it well enough. Did they overrule Sardari Lal? Did they distinguish Moti Ram Dekka? Look at these 2 words I'm going to ask you a question for. Did they overrule the Amrit Lal Shodhan's case, and did they distinguish Moti Ram Dekka's case? Okay, what did they actually do, and what's the difference between the 2? What exactly did the court do? I'm going to come to that right now, but I'm flagging it here so that when you read it or reread it again, you should be able to find an answer to this. Now, why should there be, and like this, in Article 163, we have a similar provision that the governor will be aided and advised by a council of ministers, but 163 is different from 74. We said that there are some places where he can act in his discretion, but there's no such word of discretion when it comes to the president. And when I come to Article 239 AA, which I'll come only tomorrow, I don't want to waste my time today, it will confuse you all. When it comes to union territories, the lieutenant governor, the administrator, does he take the aid and advice of the council of ministers or not? That's 239 AA. Let's now confine ourselves to president and governor. Why should we have a aid and advice? So in order to answer this, I'm going to take one example. Last year, you studied the Hindu Marriage Act 1955 and the Hindu Succession Act 1956. In addition, there was the Hindu Minority and Guardianship Act 1956, and then there was the Hindu Adoption and Maintenance Act 1956. So we had 155 Act, Hindu Marriage Act, and then we had the other 3 Hindu Succession Act, Adoption and Maintenance Act, Minority and Guardianship Act. Now the 4 of them were compendiously called the Hindu Code. The Hindu Code Bill is how the name was given during the great debate of 1953 and 54. Let me tell you, when this was introduced, as perhaps you have studied last year, there were large-scale protests all over India. There were many people who believed that the Hindu Marriage Act was going to stop a Hindu man from taking more than one wife. Remember that the bigamy was the order of the day before 1955. Hindu men could have more than one wife. Secondly, it introduced divorce, statutory divorce for Hindu marriages. Unheard of before. Two very important things here. And then it allowed for partition in Section 6 of the Hindu Succession Act, and after the notional partition in Gurupad versus Hirabai, as you've studied, women also were given a Class 1 heir status. So daughters, now of course they are co-partnership, but I'm talking about 1956. That itself was a giant step forward, that you are moving away from survivorship, you are moving away from co-partnership. Co-partnership continues, but the father's undivided share in the co-partnership would go to all Class 1 heirs. That is Section 6 for us. So you can see that this was completely rocking the boat. Society was really taken aback. When these two bills were passed by Lok Sabha and Rajya Sabha, it came before Dr. Rajendra Prasad for signature because it had been passed by Lok Sabha and Rajya Sabha. Dr. Rajendra Prasad did not want to sign. He actually felt very strongly that these were going to destroy the nature of Hindu society. And the very good, interesting account of this in Granville Austin, Working a Democratic Constitution. It has a nice little bit on it. And so Dr. Rajendra Prasad said, no, I don't want to sign. And at that time, the Attorney General was Setalwad. Have you heard of Setalwad?
MC Setalwad.
He called him and he asked him for his advice. And he said, look, I don't want to sign this. I think it's wrong. I think Parliament has made a mistake. The Congress party was split down the middle. There were large-scale protests all over India. But Pandit Nehru was very clear. He said, no, we have to change society. The question was asked, why aren't you doing it for other religions? He said, that cannot be asked. We've picked this up first on the agenda. I'm going to take it through. He put his entire integrity behind this Hindu Code bill and pushed it. And Dr. Prasad said, I don't want to sign. And then he took the opinion of Dr. Setalwad and he said, he asked him two questions. One, he said, I don't want to sign. And the other question that he put to him is even more significant. Okay, it didn't happen at the same time, but he had another question. He said, look, under Article 53, I am the Supreme Commander of the Armed Forces. Why can I not directly write to the general in charge of the Indian Army and ask for information? Is it necessary for me, through protocol, to route my question through Prime Minister and Defence Mantri, Raksha Mantri to get this information? After all, 53 makes me the Supreme Commander. He asked them these two questions. And to both of them, Setalwad said that no, while there is a position of a president, we have a parliamentary form and it is a government that is answerable to Parliament. So though you are the Supreme Commander, that army is not really under you, it is under the government. It is only when the government says the troops will be deployed, only when the government says that we will go to war, and when the government makes its executive decisions, that's when the army will move. And so even getting information will have to be routed properly through the channel of Prime Minister and Raksha Mantri. Regarding the other, he said no, because of accountability, if Parliament has passed it, really, morally, you should not exercise any power and withhold the signature. And in any case, Rajendra Prasad ji signed it, and as they say, the rest is history, and they became a law. But this principle that, it is the government that is answerable, had an even deeper basis than just India. In Nazi Germany, there is I'm going to go a little bit into German history and the writing of Carl Schmitt. Have you heard of Carl Schmitt? Anybody?
Yes, ma'am. He is an intellectual of Nazi party, along with Martin Heidegger.
Martin Heidegger, and both of them became card-holding members of the National Socialist Party, the Nazi Party in 1932. Martin Heidegger and him, that's true. And then the question was, at the end of Second World War, did they recant? But let's come back to Carl Schmitt, because Carl Schmitt was a constitutional lawyer for Germany. And I'm going to tell you a little story of the Weimar Republic for us to understand why this aid and advice is so important. Okay. The Weimar Republic came into existence at the end of the First World War, and Germany moved from becoming a monarchy to a republic. Remember that the World War I, one of the triggers for World War I was the Kaiser being assassinated. Okay, so from a monarchy, Germany shifted to a republic, and a parliament was created. It became what we call a constitutional democracy, and the parliament was set up. And this parliament is a very beautiful and well-known, the Reichstag of the German parliament. Okay, and that's where the Brandenburg Gates. You may have seen it in films, etc. It's a very historic place, really, and a grand old place. Now, Germany began as a federal republic, and it had different provinces. And just like I was mentioning to you, the Swiss had cantons, Germans had lands. Okay, Lund land, I don't know how you pronounce it. I'm calling it land. Okay. Lander. Each of those landers were their provinces. Now, Article 48 of the German Constitution allowed the president to exercise. The president was, of course, known as the chancellor. To exercise some powers. Okay, and very famously, various powers were exercised. And Carl Schmitt, who was, in one sense, you could call him the ideologue of Nazi Germany. He was the constitutional thinker for the regime that Hitler was about to develop. And so his thinking was quite acute, a very well-respected constitutional scholar. And, there's been a sort of a revival of Carl Schmitt of some sort. And people are looking at his readings, and it's been republished, etc., etc. Now, what Carl Schmitt basically advised the chancellor is that using your powers when there is an emergency, you have overriding powers, and you can decide anything that you want to do when there is the emergency. And therefore, the doctrine of necessity, the doctrine which is used in emergency matters, was a doctrine really developed for the first time in constitutional theory by Carl Schmitt. Okay, that is when it is a emergency situation, then you are free to work without any problem of checking with Parliament. You can even go contrary to any law if emergency so demands it. And that was a power that really Hitler Germany drew upon through the 1930s. Decrees after decrees were issued using this. The second point that he made is that when there is emergency, you have to exercise these extraordinary powers, going, as he put it, beyond legality in order to restore law. Look at the elegance of this argument. It's a very frightening argument, but look at the elegance of it, okay? That is where extraordinary circumstances happen. Don't be bound by law. Go beyond it. Don't ask, is this lawful or legal, or the legality of it. Do whatever you think fit, because only if you did that would you be able to restore law and order. And therefore, this theory itself creates the supra-leader. The supra-leader who is omniscient, omnipotent, omni-everything, who can do whatever is required in these times. And certain actions, he said, there can be no lawful way of the means to exercise those powers will never be provided in a constitution, because if the constitution was to provide for all these extraordinary circumstances, it could not simultaneously also provide for lawful ways of discussion in parliament, etc. So that can never be provided, because there's a tension between these extra legal methods and powers that you have in times of emergency and the normal ways in which constitutional government must function. Now, the writing of Carl Schmitt and what exactly happened in Germany was a reality that every country that was drafting its constitution after World War II was well aware of. It was a very bitter lesson that we all had, and therefore you have the aid and advice put in Article 74 that all presidential actions, the president is the head of the state, no doubt, but for all matters, it is the government which will aid and advise the government. We didn't want to have a runaway chancellor who just run away and do various things. Okay. So the logic of having 74 is a logic that is embedded in all that happened in Germany and the writing of Carl Schmitt. But yet, I have to tell you, so if you want to issue a presidential proclamation for emergency, if you look at our constitution, we'll come to that when we come to the units dealing with topics dealing with emergency. Our constitution has laid down the procedure or the steps that must be taken before proclamation of any of the emergencies: financial emergency, internal emergency, external. The procedure and the grounds both are laid down in Article 352, Article 360 for financial, 352 for internal and external, and in one sense what we call President's Rule, which is an emergency of a milder sort, right, when you dispose of a state government. Both the procedure to be followed as well as the grounds on which it can be done. And that's a learning from the way in which the Weimar Republic completely got destroyed by them using one blank check, carte blanche, that had been given to the Chancellor in Article 48 of the then German Constitution, not the present one. This one is called the Basic Law of 1949. I'm talking about the 1919 one. The only power that is still exercised without any procedure or any grounds, even now in our Constitution, is this most understudied provision called martial law. There is neither any procedure laid down about how martial law is imposed, nor are the grounds laid down. What do I mean by grounds? For example, in 356, the ground for imposition of President's Rule is that there must be a breakdown of constitutional machinery. For imposition of external emergency, there must be a threat to the security of the state. The grounds is actually written in the Constitution, particularly even after the 44th Amendment. It's all there. This is one where neither the grounds or the procedure are there. So in one sense, it is similar to the 48 that I was talking about. But the learnings of the kind of overwhelming and overriding power is the reason that we have the aid and advice to indicate that the president is under in one sense. When I use the word under, of course, it's a very high constitutional office, but he is bound by the aid and advice. I don't think under and over would be correct words, would be bound by the aid and advice of. This is the historical background. Now, you have an aid and advice. Now, Shamsher Singh's judgment, which I hope all of you have read till now, is going to answer the following questions to us. What is the area of aid and advice? When it says his function, is it only the executive function? We know partakes of some legislative function. It partakes of a variety of executive functions: legislation, policy, implementation, law and order. Does it cover the whole thing? Does it cover Article 72, which deals with the pardoning power? What is all the scope of that aid and advice? Then we already saw in the last class, so I don't want to waste my time now, that the amendment now says that once the president can send back the file, but after it is sent back, and if again the question is asked, then the president will have to accept the aid and advice and sign it. Has that happened? I gave you the example of the Hindu Code Bill. Once before, also one Post Office Amendment Act, President Zail Singh had an objection to it. He sort of kept the file with him. In the meanwhile, Parliament lapsed, and then that government of the day just let it go. The file never came back. But had it come back after the 44th Amendment, 44th Amendment, he would have had to sign and give it back to the president. Now let's come with this little background. Let me come to Shamsher Singh's case, and we're looking at two things. What is the area of aid and advice? And number two, when it comes to Article 163, what are those specific areas over which governor would still exercise his discretion and over which the aid and advice of the state government would not apply? And the third question that I have is there, in those areas of discretion, would the governor be bound by the president's advice? He's not bound by the government of the state, but is he in turn bound by the president's advice, or does he act truly in his own discretion? So let's look at now Shamsher Singh's case. I hope, we don't use expressions like pocket veto. Okay, that's such an American expression. That I am not wanting to use it. No time limit. That's what President Zail Singh did. He just kept it. Okay. Now let's look at Shamsher Singh. Now this is a case that arises from service jurisprudence. We have two judicial officers appointed to the subordinate judiciary in Punjab under Article 234 and 235. We do not teach Article 234 and 235. We do union judiciary. I'm not going to be teaching you subordinate judiciary, but because I reckon that all of you would be trying to get a job many of you would want to become and write the judiciary exam, you must look at 234 and 235. Okay, so these people were appointed. Once they were appointed, they were on probation. There are two people. One is a Mr. Agarwal and one is our own Mr. Shamsher Singh. I want somebody now to tell me, I want to do this quickly before I come back to the constitutional questions. I'm going to go to Article 311, deal with my service law in 5 minutes, and then come back to the bigger constitutional questions. So these are two cases under Article 311. As I mentioned in the previous class, Article 311 says that people who are in services under the state. My first question is, a judge who is appointed to the subordinate judiciary by writing the judiciary exam, is such a judge under services under the state? Is he covered by Article 311 or not? Or is it only civil servants and armed forces who are covered by 311? When you read this judgment, what was your answer to this? Hanji, who has read the case? Are they covered by Article 311? Yes. Who would like to answer? There are so many of you sitting in class. Somebody has to answer. Nitansh, why is that no? Why are they not covered under Article 311? If they are not covered under 311, they can be removed. Why did they have an inquiry?
Ma'am, they were covered. Because there was a punishment, yes. If there is a punishment, then they are covered by 311. You cannot terminate them without the inquiry.
without the inquiry. Now, the point to note is, since you're all budding judges of the High Court, Supreme Court, and lower judiciary, looking at the way in which executive power is exercised in India, and we were looking at Article 74, and I hope that you can tell me at the end of the class, okay, Surya? I won't be able to note down like this. Have you all read the case and come?
दोस्तों, अगर आपको आज का लेसन पसंद आया हो तो वीडियो को लाइक करें। इसी के साथ अगर आपने अभी तक हमारा चैनल सब्सक्राइब नहीं किया है तो सब्सक्राइब के बटन पर क्लिक करिए और बेल आइकन दबाना ना भूलें, ताकि आपको एजुकेशन से रिलेटेड नए नए अपडेट्स मिलते रहें। और अधिक जानकारी पाने के लिए आप हमारे फेसबुक और इंस्टाग्राम पेज से भी जुड़ सकते हैं, जिसका लिंक डिस्क्रिप्शन बॉक्स में दिया गया है। धन्यवाद।